Before I start uh, and play Justice Scalia's famous, very famous dissent in Morrison v. Olson, um, involving the independent counsel, uh, similar to the special counsel that we're all familiar with the old Russia thing. And politics aside, I want to address that, as well as the importance of uh, our very unique form of government. Um, the framers divided the power of the federal government into three branches. It's a radical innovation, um, and they did they they did. For example, the legislature is bicameral for a reason. It's meant to be a hard process so that there aren't knee-jerk reactions. Um, and that's why we have the House of Representatives closest to the people. Uh, you could say they're kind of like at the kids' table at a dinner, and then the senators are like, the adults in the room. No disrespect to any representatives. Um, so that's very important, and to those that want to get rid of the our system, where each state is represented by two senators, um, that would effectively um, neuter our bicameral system. Uh, when the Supreme Court in the 60s, Reynolds v. Sims, Baker v. Carr, those cases, ruled that each legislative districts had to be, one person, one vote. Um, it changed state legislatures significantly, because before they had county representative systems where each county had two senators or something like that, Georgia, Florida, etc. Um, so when that happened, both houses effectively became, you know, the same, and states have done different methods to try and overcome this. But the point I'm trying to make is we are a constitutional republic, not a democracy, that in the direct sense. We have obviously elements of direct democracy. We vote for a president, for example, and it's not perfect, but it is our system, and it is the best. Um, and we shouldn't throw the baby out with the bathwater. The separation of powers and its roles in protecting individual liberty and the rule of law can sound pretty abstract, as Justice Gorsuch put in his new book, A Republic If You Can Keep It. Um, and he illustrates several examples of what happens when the separations of powers are violated, in the form of administrative agencies that can tell federal courts, no, this is how you'll rule, even though the judiciary's job is to say what the law is, not what it should be or what they feel it should be. Judges aren't super legislatures. Courts aren't super legislatures. Um, why would you want them to be? Why would you want unelected judges with life tenure making social policy? You wouldn't, which is why I subscribe to textualism and originalism, essentially um, reading reading the statute as it's written, following grammar and whatnot, and just standard English. Um, and then originalism, reading the Constitution and interpreting it as it was written at the time. Now that shouldn't be mixed up with strict constructionism, which is a crazy concept, and nobody's a strict constructionist. It should not be mixed up with with uh, with originalism. Strict constructionism is dangerous. It's well, the First Amendment example. The First Amendment was you know at the time there weren't computers, so it doesn't apply to computers. That would be strict constructionism. Whereas originalism, um, you're not doing that. You're applying it to the current era, but you're not modifying policy. Um, you're applying some level of common sense and getting into originalism and textualism, for that matter, is not a rabbit hole or a black hole, but um, it is quite the topic. But I implore you to to look into it. A Republic If You Can Keep It by Neil Gorsuch. It's a good book. Um, and I know people think the courts are overly partisan, but presidents nominate judges who have views that they feel will be beneficial to the country. It's not judges with life tenure don't have to answer to the president. As soon as they are commissioned, they they answer to themselves essentially, and they can only be removed by impeachment, which is something I'd encourage if a judge were to be out of line. That's the way the people can regulate the judiciary. The judiciary shouldn't be making policies. If a law is wrong and it's unconstitutional, the courts need to strike it down, even if it's at the cost of, um, ruining a good social policy. Um, and, uh, and and you can't blame the judiciary for that entirely, really, at all. One could say, because it's the Congress's job to make the law, and they need to make the law good. We elect them, and they are paid to write the law based off of social policy, based off of what you want. So that's the role of the legislature. The judiciary's job is to interpret the law and say what the law is. And they shouldn't be looking into legislative history or anything. They should look at what was passed by the Congress and signed by the President. So with that said, I'm going to play Scalia's dissent from the bench in Morrison v. Olson. And he'll cover a significant portion of our system of government. And I also have the opinion, his dissenting opinion, up for you to read as well. So with that, I will shut up.
I'm the one of the 8 who filed a dissent in this case. And I suppose when one dissents from as many of the court's decisions in one day as I have today, you get to discuss it. I discuss it because I think it's one of the most important opinions the court has issued in many years. To many people, it may seem that this case is of some political interest, but is not likely, now or in the future, to have any proximate effect upon their lives or the lives of their children. It does not, after all, involve freedom of speech, freedom of the press, freedom of religion, or any of the wonderful guarantees of our Bill of Rights. That is wrong. In the dictatorships of the modern world, bills of rights are a dime a dozen. What makes ours work is a governmental structure, a constitution of government, designed by 55 extraordinarily wise national leaders over the course of a 4-month convention 200 years ago last summer. That structure was designed to prevent an excessive governmental power, which is always the first threat to liberty, from coalescing. To achieve that, two principles were absolutely central. One was the separation of powers among three branches. The second was an equilibration of powers, so that none of the three branches could become too strong. For the latter reason, the legislative branch, naturally the most powerful because it is the closest to the people, was intentionally weakened by dividing it into two separate houses, differently elected, that would not always agree. And for the same reason, the executive branch was strengthened by giving it a role in the legislative process, the veto power, so that it could defend itself. And also for the same reason, the executive's power, unlike that of the Congress, was not divided, although that had been proposed at the Constitutional Convention. Article 2, Section 1 provides that the executive power shall be vested in a President of the United States. The Court's opinion today does not deny that what is at issue in this case is purely executive power, quintessentially executive power, the power to prosecute for violations of the law. Yet it holds that, despite the Constitution, a statute can enable this power to be exercised by someone who is not entirely subject to the control of the President, a mini-executive, so to speak, with jurisdiction over a very small, although in my view, a very important area. That independent counsel has authority to investigate and prosecute, whether the President thinks it is justified or not, the closest advisors to the President and indeed the President himself. We allow this mini-executive to be created because, in our view, and I quote the Court, the President's need to control the exercise of the independent counsel's discretion is not so central to the functioning of the executive branch, close quote, as to require complete presidential control. To begin with, I disagree with that judgment. I suspect that if a president were asked to list the 10 powers he thought most necessary to protect himself, practically and politically, within our governmental system, the ability to decide whether he or his closest advisors should be criminally prosecuted would surely be among them. Placing this power in someone else has, first of all, an intimidating effect upon his advisors. The present investigation, for example, arose out of a bitter dispute between the executive and Congress concerning the scope of executive privilege. Respondent Olson played a key role in that dispute, after which a committee of Congress conducted a 2.5-year investigation of his activities, including testimony before Congress, and then sent a 3,000-page report to the Attorney General, requesting the appointment of an independent counsel. For reasons I describe more fully in my opinion, the Attorney General probably had no choice but to comply with that request. I do not know, of course, whether Mr. Olson is innocent or guilty of the matters that are under investigation. But I do know that those advising the President and representing his interests in testimony before Congress in the future will, whether they are innocent or guilty, certainly act with a reduced degree of zeal. Taking away the prosecutorial discretion hurts the President, secondly, in a political manner, by eroding his support among the people. Nothing is so effective for that purpose as being able to say that X number of the President's close associates are under investigation or indictment. In the last two administrations, 9 highly publicized independent counsel investigations have reduced the political strength of the presidency vis-à-vis the Congress in this fashion. But more fundamentally, it does not seem relevant to me, as it does to the Court, how important the particular element of executive power taken away from the President may be. Even if we were good at assessing that, which today's opinion convinces me we are not, the Constitution did not leave the President's powers at our mercy. It says that the executive power, not some executive power, shall be vested in a President of the United States, not a President of the United States and others. How incompatible what we have done today is with what has until today been our political traditions may be made clear by thinking what the result would have been if a statute had been passed seeking to do the same thing to one of the other two branches. Would we have allowed Congress to pass a statute saying that henceforth one tiny bit of the power to enact laws relating to bubble gum, for example, would henceforth be exercised instead of by the House and the Senate by some new body established by statute? Or would we have allowed Congress to take a tiny bit of the judicial power, the power to hear bankruptcy cases, for example, and give it to tribunals other than Article III courts? The answers are obvious. A little over half a century ago, in a case called Humphrey's Executor versus United States, Justice Sutherland wrote an opinion announced the same day as the case that invalidated the National Industrial Recovery Act, which prevented President Franklin Roosevelt from removing the commissioners of the Federal Trade Commission. That was itself a reversal of our prior law regarding the president's powers. Many, including President Roosevelt, thought it an action motivated by hostility to the president's programs. But Humphrey's executor preserved, at least in theory, the line that the Constitution established. It allowed the restriction upon the president's power because it found that the Federal Trade Commission did not exercise purely executive power. Today, however, the Court concedes that what we have before us is precisely that. It effectively overrules Humphrey's executor and says that in the future, how much power can be taken from the president will depend upon, quite literally, our case-by-case evaluation of whether what has been taken from the president is too much. I do not think we are qualified to decide that. More importantly, I do not think we are authorized to decide that. All of us are familiar with and proud of the phrase that we think epitomizes our political system, a government of laws, not of men. Not many know where that came from, which is part the first Article 30 of the Massachusetts Constitution of 1780, which reads in full as follows: "In the government of this Commonwealth, the legislative department shall never exercise the executive and judicial powers, or either of them. The executive shall never exercise the legislative and judicial powers, or either of them. The judicial shall never exercise the legislative and executive powers, or either of them. To the end it may be a government of laws and not of men." That is how central the founders of our republic thought the separation of powers was to our system. That is what achieves the end, that it is a government of laws, not of men. And as the founders knew, separation cannot be preserved without equilibration. Today's decision, which departs from the text of the Constitution and gives no reason for the departure, except that a majority of this court does not think that the power taken away from the president was too much, is not, in my view, the operation of the government of laws that the Constitution intended. Indeed, it does not seem to me to be the operation of a government of laws at all.
So that was a long excerpt, and maybe you didn't follow it all, but the case, the dissenting opinion, is here, and it's very important, and I think people need to take a step back and remember that our principles are tested during difficult times, and we have to hold on to our principles when things are tough. Our constitutional rights are there not for when it's easy. For example, the First Amendment. There would be no point of a First Amendment, freedom of speech, if your form of speech was popular with everyone. But it's there to protect unpopular speech, as an example. And to those that worry about the president and think the president should be prosecuted, well, if the president breaks breaks the law, he should be prosecuted when he leaves office. But the mode of the remedy that the founding fathers set up was impeachment, and indeed, with Nixon, he was impeached, and that was fairly bipartisan, because wrong is wrong. But the separation of powers is critical, and people need to remember that. And our system of making laws is critical as well. I don't want to put political overtones on what I'm saying, because I don't really think it's a political statement that I'm making. I'm making a statement in favor of our system. So I hope that you will take this into consideration when you vote and participate in other activities. Thank you.